Okay, I'm Eric Schnapper. It would be rare for me to have any involvement in a case at the district court level. Occasionally, I'll get a call from a lawyer who wants to talk through an issue at that level. Similarly, occasionally, I'll have a conversation with a lawyer who's working on an appeal in the early phases of that. But I don't think since I got to the Legal Defense Fund, I have handled a case other than in the Supreme Court or seeking rehearing en banc. Once a case is lost before a panel, that's when I'll most often hear from people or know about it and get in touch with them. It's been increasingly my view that it is often worth seeking rehearing en banc for a couple of kinds of reasons. One of them is, even if you lose, occasionally you'll get a dissent. And if the dissent points out that there's a circuit conflict and that it's important, that really strengthens a cert petition and makes the chance of cert being granted greater. Secondly, rehearing petitions work sometimes because, particularly as the Obama administration has gone forward and there become more Obama appointees on the courts of appeals, the likelihood of finding someone on the Court of Appeals who would support rehearing en banc and of getting a majority of the judges on the Court of Appeals to vote for it has been improving. Third, the standard for granting rehearing en banc, there are several alternative grounds, but one of them is that there's a circuit conflict. So a rehearing petition en banc is a sort of rehearsal for a cert petition. It's done very quickly because the time is very short, but it gives you an opportunity to sketch out the arguments and if the court calls for a response, to see how the other side's going to respond. So even if the court calls for a response and the petition's denied, there's no dissent, you still can be better off for having done that. You have a sense of what your arguments are, how the other side might respond, and you write a better cert petition as a result. Depending on what the trial work was. I mean, if you're talking about taking depositions and trying a case, it's completely different. A friend of mine, I once said to a friend of mine who's a trial lawyer that I'd be reluctant to take a deposition, and he said, "Eric, it would be malpractice to let you take a deposition." And he was absolutely right. It's a completely different set of skills, and I would have no better idea how to do that than someone walking out of law school. So if you're talking about discovery and trial, I would not be competent to do that. Motion practice is a little bit more like what I do, and appellate litigation as well. I would say it's a bit of a first cousin to arguing the same issue in the Supreme Court. What goes on in the appellate courts is actually somewhat different. For one thing, it is often the case when a case goes up on appeal that there are a lot of issues in the case. And there might be a dozen issues, and the issue that will ultimately end up in the Supreme Court is one. So it gets a tenth of your time, and you couldn't give more than a tenth of your time to it. So the issues don't get developed in anywhere near the depth that they would in the Supreme Court. So I think one of the skills you often need on appeal is the ability to have 10 different issues or 5 different issues in mind, to be thinking through some very complicated record-intensive questions and somehow striking the right balance amidst all of that, in addition to responding to what the other side says. Supreme Court litigation is typically not like that at all. It's come down to one question, and now we can go out and spend 15,000 words on one issue. And so we get into things in far greater depth than the lawyers do, and I think the Supreme Court gets into them. I mean, you think about the oral argument in the Court of Appeals might be 10 minutes aside with 10 issues. Now we'll have 30 minutes aside with one issue. So the court has the time to think through things in greater detail than the appellate courts would. So it's different. People, and then the way you make arguments is different. There's no question about that. Well, merits arguments are different from what would typically go on in the Court of Appeals in a couple of ways. One of them is just they're thought through and researched in infinitely greater depth, or at least they should be, because you've got the time and you've got the words, and you've got the, you simply couldn't develop an argument in that kind of detail below. Secondly, it happens because most of the people who, the regular participants who practice the Supreme Court a lot, are used to doing that. It simply isn't, it wouldn't be a useful or practical skill on the part of a general practitioner who does trial and appellate work to know what it's like to spend a month on one legal question. In fact, you'd go bankrupt if you spent a month on one legal question typically. And so it's just not, typical of what would go on below. In the lower courts, circuit precedent is of controlling importance. It is of no interest to the Supreme Court at all. They really don't care what the lower courts think the answer to a question is. It would be, I would cite a lower court decision if it had a nice turn of phrase that I wanted to use, but otherwise not. But in the courts of appeals, circuit precedents are of controlling importance. In the courts of appeals, Supreme Court opinions, the exact wording of an opinion is of great importance. In the lower courts tend to construe Supreme Court opinions as if they were construing United States Code. A subordinate clause in a footnote will be given great weight in the lower courts. In the Supreme Court, no. If you were to get up and say you really or decided this issue, it's in footnote 12 in a decision 12 years ago, they would think you didn't understand what you were supposed to be doing there. If they thought they decided, they wouldn't have taken the case. No, the Supreme Court doesn't care what the lower courts think. It's not bound by them. And the Supreme Court it's construing the statute. It's not construing its earlier opinions. The earlier opinions may play a role in the way they write the decision. Occasionally, an earlier opinion will show up in an oral argument. But if you were to rate a dozen oral arguments, it would be uncommon to see someone who'd done this before say, well, you already decided this some point earlier. They almost never have decided it earlier. But the lower courts will try to read things into it the way a person of faith might try to construe the older New Testament. In the Supreme Court, it's like litigating before the Lord. You wouldn't go, well, you said this in Leviticus, and he'd roll his eyes and come on, tell me why it's right and wrong. Don't bother me about Leviticus. Not to suggest that the Supreme Court's quite at that level. The other thing that matters to the Supreme Court a great deal is the exact contours of the rule that a party is proposing. And that's because the Supreme Court will not generally be able to return to this issue again in our lifetime. So if it's going to hand down a decision about when you can search a cell phone or any number of other issues, there may be 1,000 cases that will come up that will be affected by that in the decades ahead. They don't have the time to go back and look at any of those. So rather than just deciding the case before them, they are very intent, and properly so, on framing a standard which will be sensible and administrable for the lower courts to use in the future. That does not loom large, as large certainly, with the lower courts, because if there's another appeal next year about this issue in the Ninth Circuit will hear it. And if they didn't say it quite right in the previous opinion, they'll say it a little bit differently. But the Supreme Court can't do that. So although appellate courts to some degree think about this, it is of overarching importance in the Supreme Court. And to the point where I have occasionally written, where every time I write a brief, I'm intently focusing on the question of what the legal standard is I'll be asking the court to adopt. And if you listen to an oral argument, you will often see the court struggling to find out from the lawyer what rule they're proposing. And they do it often with hypotheticals. Say, what happens if A and B and C, and you answer. They try to piece together from what you're saying what the rule is proposing. And if you give an answer that's inconsistent with the rule that you seem to be proposing 5 minutes ago, then they really are unhappy, and legitimately so, because they don't know what it is that you're proposing. I try to give that a lot of thought in writing a brief and a reply brief, and I have upon occasion gotten up and started there. I think to some degree to the relief of the court. It's a little cheeky to do that. But I could conceivably get up and say, we propose that you adopt the following rule regarding section 1234. And right there it's on the table. And though I will then get half an hour of challenging question about whether it's a sensible rule, the court knows what's on the table from the outset. I've done that occasionally. That is my experience, is that is generally true. The one circumstance it would be less common is if you had a question that was really unique, that wasn't going to come up again in all likelihood. Conceivably, the validity of the Affordable Care Act. There may be nothing quite like that on the horizon for decades. But most cases, it's true, and I think it's true in any area of the law. No, I think it'd be true in both. I think it would be true. You could have a situation where there's a dispute about whether there was enough evidence on some issue. Now, that would be an unusual case. Typically, the Supreme Court wouldn't take a case like that. But if you had a case of presenting that kind of issue, it might loom less large. My experience is those cases often have embedded disputes about the governing legal standards, and you fall back to that. In some sense, the losing party has to. If there's been a decision below on some fact-bound issue, there's a presumption insofar as it's just a factual issue in favor of the decision below. The losing party is going to want to advance some argument that's legal in nature, so that presumption in favor of fact-finding would drop from the case.